Okay, so the trait that I want to talk to you about today is the trait of vengefulness. Some people believe that vengefulness may be correlated strongly with aggression. The opposite trait that would be associated with vengefulness would be one of forgiveness. Now, as you know from my background, I have worked previously as a state prosecutor. So the cases that I will be discussing will be in the context of my work there. And what is important to understand is that while in the criminal prosecution function, we may not necessarily have mediation in the sense that you all are used to dealing with, but that doesn't mean that mediation doesn't take place in its own way or its own fashion. Plea bargaining is a huge part of the criminal justice system. In fact, it is said that most cases do not proceed to a full-fledged trial. I think something along the lines of 90 or 95% of cases actually end in a plea bargain. Because quite frankly, the criminal justice system is not a system that is easily like if you just took every case to trial, the system would literally self-implode because it does not have the resources and capacity to handle every particular criminal defendant taking a case to trial. So it is necessarily understood that most cases go through some sort of plea bargain process, and only a small handful will actually go on to a full-fledged trial after there's been some sort of impasse in plea negotiations. So the case that I want to discuss with you involves a case of juvenile delinquency, which is part of the criminal justice system, but not really per se, because when you're dealing with juveniles, you try not to use the normal language associated with the criminal justice system, because we try not to think of juveniles as full-fledged criminal defendant adults. We think of them more as children, minors who are in the system, who commit acts that are classified as delinquency, and we focus less on the punitive aspects and more on the rehabilitative aspects, because we believe that children are still going through a process where their brains are growing, their brains are maturing, they're not fully formed. In fact, the human brain may not be fully formed until possibly after age 25 and up. So through the early years, going into the teens, and even as a young adult, the system tries to go easier in the sense that rather than being about punishment, it's more about trying to get the person on the right path, that there's a potential for reform that maybe doesn't exist as much with much older criminally charged adults. So in this particular case, it was a sexual assault or sexual molestation that was involved. The accused was a juvenile who was 14 years of age. The two victims were twin sisters, in fact, and each of them was 6 years of age at the time that the acts of delinquency occurred. In essence, the 14-year-old had forced these two 6-year-olds to engage in acts of sex. I don't want to go too much into the details, but you know, as all of the people involved were females, it was an act of oral sex, and clearly there was a familial relationship. The 14-year-old was in fact the older cousin of the two 6-year-old sisters. And so this cousin took advantage of her younger cousins. And that in of itself would be something that we as humans would find as disgraceful or reprehensible. It would bring disgust to us hearing these types of details and facts. But nonetheless, any attorney working in the system, whether they be the defense attorney representing the juvenile delinquent or a prosecutor representing the people in the state of Florida, has to look at all this very neutrally and each play their roles in a fashion that is free of bias, is free of any personal feelings or predilections about the events and how they occurred, and best on how to each, like I said, serve their own function. For the defense attorney, what course of action will be best for the juvenile delinquent, and for the prosecutor, what act will help society to be able to get justice for the victims, but also balancing that against the fact that it is a juvenile delinquent involved, that we're not seeking straight punitive measures, and that we're trying to get help, right? Typically, in these cases, a psychologist or psychiatrist is involved. In this particular case, the longtime psychiatrist that we used, whether it was in the juvenile cases or the adult cases, was usually typically Dr. Chekowicz. And he would do some sort of evaluation, and he would determine the best course of treatment that would be imposed on a juvenile delinquent or criminal defendant who is either taking a plea or being sentenced to some sort of sentence that involves what would be known as mentally, sexually disordered offender treatment. And typically in these types of cases, when that's done, there's some sort of deal that is made that well, I'm going to speak in the juvenile delinquency context, that the juvenile must plead and accept responsibility for what they've done, undergo treatment, and usually whatever other recommendations the Department of Juvenile Justice makes regarding how rehabilitation is to occur. And in exchange, they undergo some sort of supervision of the department, whether that be, like I said, some sort of secure facility term, which I don't want to call it jail because it's not jail in the juvenile system. It's just that they are confined usually to a particular facility or camp, and they're not allowed to leave until they have served their time. But in this camp or facility, things are taking place which are helping to reform that juvenile. Then afterwards, they would continue to have follow-up treatment while being on probation. um, usually complying with the terms of the mentally disordered sexual offender program. And then when the entire process is done, if the juvenile has been completely compliant, then we would go back to the court. We would have the judge vacate the previously entered plea admitting to the acts of delinquency. And once that takes place, then we would ask the court to dismiss the charges altogether. And so then the clerk of the court would reflect on the juvenile's record that they successfully completed their sentence and probation, but that the case is ultimately dismissed. So it is a dismissal in effect. And this is done so that we don't permanently scar this juvenile for life and leave them with a long-standing record that would reflect that they've committed some sort of sexual offense, but also enough to signal people who work within the system that this person has had a previous case involving this and that they successfully completed the terms of their deal and then earned the dismissal in that way. So a lot of these cases were resolved with that type of a plea negotiation. But in this particular case, there was a problem. The problem was that the custody of the two little girls that were the victims was with the father, and that the father, being the primary custodial parent, or I guess now it's called time sharing, but at that time it was still considered to be custody, that the father would not consent to this type of deal. Now, as a prosecutor, we represent the people of the state of Florida, but that doesn't mean we don't give victims rights and therefore a huge say in the outcome. And so because of that, because he is their legal guardian, every time the subject of plea negotiations was raised, he vehemently objected and would not agree to any terms like what I had described previously. So what's the trait involved here? Again, it was vengefulness, because the father was not blood relations with the cousin. So the father had no true familial tie to even want to feel sorry for the cousin and what had happened, and recognize the fact that the cousin was still 14 years of age, still a minor, still someone who committed a offense of opportunity, as we would call it, and that they could atone for that mistake and they could go through rehabilitation. But the father didn't want to see eye to eye on that, and so his villainous trait of vengefulness had manifested itself. And the thing is that you can't feel bad for this person, because, feeling bad, I mean, in the sense that you would think that he is this despicable person. He's a father who understandably is upset about what happened to his little girls. But nonetheless, the path to ruin can still be paved with the best of intentions. He had let the vengefulness creep into his heart such that he grew to become the villain of the story. Because there were still other things that had to be taken into consideration besides just the fact that we had to be more understanding of the juvenile delinquent in terms of their age and their potential for reform and their poor judgment. We also have to take into consideration the fact that if we go to a trial then we are going to re-victimize the victims. We are going to re-victimize the victims. And that is a problem. Because I had watched the video, usually in these sexual offense cases, right away involving minors, the children are taken to the children's center where there are specially trained staff who work with them to immediately record their testimony. Now, it's not anything that's admissible in court per se, because obviously for us to be able to truly use the testimony in the way that it should, the defense should be involved. They should be allowed to view the testimony. They should be allowed to object to any testimony that might be improper or that might be prejudicial or that might violate some rule of evidence. And they should be allowed to cross-examine and question the witnesses, in this case the victims, before it would truly be admissible evidence. But it's still done for investigators and for people within the juvenile system, or even in the adult system. I mean, there are adult cases involving molestation against minors as well. But nonetheless, we want to get those events recorded so that we can see not only what took place, but also how these witnesses present themselves very early on. And so these little girls were 6 years old. Being 6 years old, they did not have the full understanding of someone who was older. So even though we have these trained professionals that are trained to get the story out, they were struggling with these little girls because it's a very traumatic event for them. They had a tendency to close down or shut down because it was so horrifying. Even though they may not necessarily understand it as adults do, they did understand that what was going on was definitely wrong, and it was painful, and it would bring up really terrible memories for them. And so, having watched this video and having read through the reports, I realized very early on, we're going to have a problem with these two little girls. And that problem is a proof problem for the trial. Now, I brought in the little girls as well to conduct my own interview of them. And I told, the parents to leave the room, and I was with them alone. Because, at trial, I would be the prosecuting attorney soliciting the testimony from each of them. So if I can't do this now, what makes me think I'm going to have a better chance doing it during the trial? And there are other tools that we might have at our disposal, like have them testify by closed circuit television, things like that. But even that, there are issues with that because they may have challenges under what's a case known as Crawford v. Washington, whether or not that is sufficient to guarantee a defendant their full right to confrontation and cross-examination. So at the end of the day, just because it happens to girls this young doesn't mean that we relax the rules of the justice system. There still must be a trial. It still must observe the rules of procedure. The evidence that is brought out must not be objectionable. It must be substantial. It must be competent. And so they performed worse in my interview than they did at the Children's Center. So it became clearly obvious that not just considering the juvenile delinquents' point of view in terms of wanting a plea deal that would spare them a more harsher sentence by focusing more on the rehabilitative aspects of a plea bargain that we could craft, but also the fact that I would now have to subject these victims to something extremely painful, and I might not be able to prove my case, which would be even more traumatizing, because now you have these little girls, they're pouring their hearts out, the parents are there, everybody's seeing this, and then the juvenile judge could very well say, you know what, I don't think you've proven your case, state of Florida. Therefore, I'm going to have to find this juvenile delinquent not guilty. I've had cases like that. I've had cases where I was successful, and I've had cases where there were just issues dealing with young children that the defense was able to poke enough holes in the case that we were not able to carry our burden beyond a reasonable doubt, which is the same standard for criminal adults as well. As I said, just because this happens in a juvenile proceeding, just because minor victims are involved, doesn't mean the rules get relaxed. And so I tried to explain this to the father several times. Now, mind you, the father from day one had a very antagonistic attitude, because that trait of vengeance had really corrupted his heart, and it had really hardened his heart to the point that he didn't want to hear anything from anyone. All he wanted was the maximum possible punishment that he could inflict on the person that hurt his babies. Now, that doesn't sound terrible in theory, because if your children were victimized, you would probably be out for blood too. But then you have to step back and you have to say, well, but there's still more going on than meets the eye here. It can't just be all about vengeance. All of these things have to be taken into consideration that I previously discussed. And the father refused to listen. The vengefulness that was his supervillain trait had created selective information processing. And that's something that is in psychology as a concept, right? That we have what they call confirmation bias. Confirmation bias means that we as people like to take cognitive shortcuts at times. And when we take these cognitive shortcuts, what we're doing is we're coming to a conclusion where we haven't examined every single thing that's out there. We haven't weighed everything carefully. We haven't said, you know what, let me listen to everything and keep an open mind. And then with that open mind, eventually I will see that, you know what, I don't like what I'm hearing, but I have to see to reason that this is the best outcome for all. And sometimes, you know, that's what happens in settlement negotiations, is that it's not always necessarily that one person comes away happy and the other person not happy. I win, you lose. Sometimes the outcome is something that everyone might have some issues with, but it's the least offensive outcome that one or more parties are willing to accept to resolve something, right? And so that's what I was trying to get the father to see, that rather than go to trial, rather than victimize his two daughters, we have to look at the big picture. How do we get some justice, spare them this pain and anguish, and do it in a way that is fair under the rules of juvenile delinquency. He didn't want to hear that. All he wanted to hear was, and I think I quote, "I want you to put that little girl, that 14-year-old girl, under the prison. Every possible horrible punishment you can inflict on her is what I want from you as a prosecutor." And I told him, "Sir, that's just not the way this works. She's not an adult, and I have not charged her as an adult, because it is possible for some juveniles to actually go do criminal court and be treated as an adult in criminal court, but that wasn't this case. This case was not charged up to adult court. It was still within the juvenile system. Therefore, I must deal with it as we deal with cases in the juvenile system." And so I tried and I tried over and over again, numerous ways, to try to get him to see to reason. So the question is, how do you deal with this villainous trait of vengefulness? How do you get past the impasse? My answer to that is, you have to be frank, and you have to be honest, and you have to lay everything on the table. This isn't a game. This isn't I favor one side over the other. In a very real sense, even though I represented one side of the equation, I still have to do justice. And justice means justice for all. Criminal prosecutors or juvenile prosecutors can't just engage in sneaky, underhanded tactics to get the outcome they want. Although there are prosecuting attorneys who have engaged in sneaky, underhanded tactics over the years. The Duke Lacrosse case is a prime example of this. And the outcome reflected exactly the fact that the prosecutor forgot what I just talked about. Right? Because the prosecutor hid evidence, withheld evidence, and in essence allowed a case to go forward without the prosecutor fully fulfilling their duties. It's not our job to win at all costs. Our job is to seek justice. Therefore, is anything that would seek to exculpate a defendant, that would be considered to be Brady evidence, and that would have to be turned over to the defense so that the defense can prepare a proper defense for their client. Now, if I'm all about winning the game, then I'm going to withhold that, and I'm going to become a villain myself. But that's not what prosecutors are supposed to do, and that's not what I would ever do. Which is why I'm stressing that the best way to attack this vengefulness is with honesty. I never was trying to pull a fast one on this father. I completely understood. I have children of my own. I would be extremely upset. I can understand his position. I can empathize with his position. I can sympathize with his position. I can put myself in his shoes. And so I would use my honesty, I would use my bluntness, my frankness, to speak freely so that there's no misunderstanding, that he doesn't think that I'm trying to do anything that would be harmful to him or his daughters. But again, confirmation bias. The confirmation bias had truly set in because of the vengefulness, the supervillain trait that had corrupted his heart and ultimately his mind. So he began to go on a letter campaign. He's writing to the top prosecutor herself, the state attorney, telling her that I'm a terrible prosecutor. I had done nothing to merit being labeled a terrible prosecutor, but he had determined that because he determined that if I did not want exactly what he wanted, then I was the bad guy. And I was in cahoots with the enemy. But these are all children we're dealing with. There can be no enemies here. It's a tragic, tragic situation. Truly tragic, and it's heartbreaking. So I tried. There's no way I could just cut him out of the proceedings altogether. That's a no-no. Again, victims' rights. The victims are entitled to their say, and he, as the legal guardian of these two little girls, was entitled to a say. So I can't go around him. I have to keep going through him. So even though he had done these things, tried to get me in trouble, I held no ill will against him, and I continued to deal with him the same way I always dealt with him. With patience, with kindness, with honesty, with bluntness, being sympathetic, empathetic, doing my best to win him over, doing my best to make him understand how dire the situation was. So after I met with his two little girls, I explained to him that, hey, I just met with them, and we went through what's known as a pretrial conference. The pretrial conference did not go well. We have an evidentiary problem. I do not feel that we will be able to prove this case properly if something doesn't change. We might still get an outcome of a guilty verdict against the juvenile delinquent. It's possible, but the probability of it is not high based on what I'm seeing. He didn't want to hear that. Again, confirmation bias. He had completely shut down and said, no way in the world anybody's going to hear this story and not come away with guilty, guilty, guilty. I said, but that's not the standard, sir. The standard is that the state of Florida must prove this case beyond a reasonable doubt. And so we have to follow the rules. We can't just go in there and hope that bias, that being inflamed by the facts, that's somehow going to make this evidence stronger than it really is and guide us to a judge giving one singular verdict and no other verdicts. That's not the way this works. And I was honest about that. He said, you're wrong. He said, you don't know what you're doing. I don't even know why you're on this case. I don't know why the prosecution won't listen to my letters. You know, the state attorney herself, right? I don't know why she won't listen to my letters. Have you removed from the case? Because you are not doing your job and you don't want to do your job. And I think you're a very lazy person. This is what he told me. Said, I've never ducked your phone calls. Every time you wanted to meet with me, I've met with you. I've never shirked down from anything that you've thrown at me, no matter how brutal it's been, and I've been honest and upfront with you. He just said, well, you know what? And excuse my language. He's like, you can go fuck yourself. Again, I can't let emotions get the better of me. I still understand him. I don't feel in any way that he's this horrible person that's irredeemable. Sometimes villains are people who are trying to do the right thing, who are trying to do a good thing, but they're going about it the wrong way. Right? There are accidental villains. Haven't we ever seen a movie or a TV show where we see someone starts off with the best of intentions, but despite all of their wonderful intentions, they don't listen. And the more they don't listen, the more they shut out the truth. And people keep warning them, and people keep telling them, you are following a path to self-destruction. But these villains don't want to listen. Not only might it be self-destruction, but it might be destruction of everyone around them. In this case, the destruction would be on the psyche of these two little girls. Because it was clear that even as I asked them questions in the most gentle way possible, they were being traumatized. It just hurt them, and it hurt me to see them hurting this way, which is why I kept bringing it to the father's attention. He told me, who is their legal guardian? I said, you are, sir. Who is responsible for them and making the decisions for them at this time? You are, sir. He said, well, then you let me worry about that. Whatever happens to them, it's on me. And that was sad. That was really sad, because he is telling me that he's willing to let these little girls undergo severe psychological trauma because he is only interested in getting vengeance. A vengeance that he can't even get. Because I explained to him how the system works. I said, even if we went to trial, even if we won, that will not, like, what you are seeking is not the sentencing outcome that's going to happen. The judge is not going to throw the book at them. They're not sending them to prison, because we don't have a prison in Florida's juvenile justice system. As I told you, the worst would be that there would be some sort of confinement to a secure, locked facility, some sort of camp, but that's not prison, and it's not meant to be prison, especially not for a 14-year-old girl. So you're not getting prison, and you're not getting every punitive thing you can think of in the book, because those are not listed as possible sentence dispositions within the juvenile statute that deals with these cases. And the Department of Juvenile Justice, it's highly doubtful they would ever recommend something barbaric, something in the lines of the torture that he had in mind for that 14-year-old juvenile delinquent. He just kept saying, I don't want to hear it. You're a naysayer. You don't want to try. You're a coward. You won't help me get justice for my little girls. I said, I am trying to get you to allow me to get justice for your little girls the best way I know how. But your vision of justice, and the justice that I understand the way our system works, is two completely different things. You're taking adult system concepts, you're trying to apply them in the juvenile arena, and it doesn't work that way. And it was never meant to, because the juvenile justice system was created precisely because in America, in the 1800s, juveniles were treated pretty much the same as adults. So you had juveniles sitting in jail or prison, and they were being treated horribly. And people began to advocate on their behalf and say, we have to find a better way. We can't keep doing this because all we're doing is ruining these children who commit 1 or 2, possibly even 3 mistakes, but nothing so serious that they're irredeemable, nothing so serious that we can't say, one day we're ready to reintegrate you into society as a functioning adult who had a troubled childhood, but we worked through it, and now we're giving you another chance. Because research studies have shown that a lot of times with juveniles, when they commit these offenses, that they're considered to be offenses of opportunity, rather than just that they are fully committed to evil, that they're fully committed to being a lifelong criminal. It's usually a judgment mistake. But again, he didn't want to hear that. So I continued to follow this pattern of being open and honest. And that's all I really could do, because there's no way I can go around him. There's no way I can trick him, nor would I want to. I have to be a straight shooter with him at all times. Now, when the case would be called in court, the judge would ask, because the judge was used to me coming in on many other cases, and many other cases, plea negotiation, plea negotiation, plea negotiation. Very rare, particularly with my caseload, which was entirely juvenile sexual offenses. I was, in fact, the division chief of the juvenile division, as well as the special sexual battery prosecutor for the juvenile division at that time. I was the only one in Miami-Dade County. This was the years 2007, 2008, we're talking. And so this judge was taken a little aback, because every time the case was called, is there a plea? No. Why not? Your Honor, I really can't get too deeply into the details, but all I can tell you is that the prosecution and the defense have not been able to reach any sort of plea resolution. The judge would look at me and say, try harder. I would say, Your Honor, I have been trying very hard. All we can do is set this matter for trial this time. He's like, I don't accept that. He said, you know what? I'm going to reset the case, and we're going to come back in 30 days, and hopefully you will tell me the answer I want to hear. So he reset the case. Again, back and forth with the father. Nothing changed. He's still telling me to go fuck myself. So I come back in 30 days. State, what's the status? The status, Your Honor, is we're ready for trial. We're going to trial. There's no plea resolution in this case. He just looks at me, he scratches his head. I don't understand. And I said, Your Honor, trust me, I've done everything. I have tried and I've tried. And I have other cases before you, and you know those cases have been resolved, but there's this particular case is going to have to go to trial. He said, well, you know what? I'm doing something new. And this is probably the first and only time that I've ever seen it. I don't know if other prosecutors have seen this, but this was the first and only time that I ever seen this. He says, I'm scheduling a mediation. Now, I just told you at the beginning of the story that in the criminal justice system or the juvenile delinquency system, we don't have mediations. All we have is the plea bargaining process. But he was thinking outside the box. And I said, is that even legal? There's nothing in the rules of procedure that provides for it. There's nothing in the statutes that provides for it. I don't even know that we could compel any parties to participate in it. And he said, well, I want you to participate in it. And I'm going to ask the defense to participate in it. And we're going to do this. And I said, well, the state of Florida does not want to offend this court. To the extent that we can honor your request, Your Honor, we will. And so I contacted the father and I told him of this development. So I told him that he and the child's mother would need to be present and that we're going to mediation. The juvenile delinquent was not present for the mediation, and the defense made that very clear up front. The defense indicated that I will be here with the juvenile delinquent's parent, which also created more tension in the room because if you recall, the delinquent and the victims were blood relations, right? They are related through the mother of the victims. So at the mediation, the father is present, the mother is present, and the father and the mother were not married. So obviously there's already some issues there because they're not necessarily co-parenting. The father has full custodial control, as I indicated. And in a way, he sort of was blaming the mother because it's her family, and he felt like she wasn't doing enough to protect the best interests of these little girls. And so now the defense attorney is there with the mother of the juvenile delinquent, and that mother is the sister of the victim's mother. So it's definitely uncomfortable. So the judge sits down and he explains that normally this isn't done. But he really wanted to try because he was puzzled that nothing could be done on a case like this. So each of us was allowed to make our presentations as to what we thought the case was about. Obviously, the defense doesn't give away too much because, remember, the defense is going to be taking this to trial, and so they don't want to reveal their trial strategy or anything like that, and they don't want to tip us off as to any weaknesses either. But I already knew what the weaknesses were. Nonetheless, we make our presentations. Then the parents are invited to speak. They say their piece as well. So finally the judge gets to the heart of it. He's just like, why are we not able to resolve this case? I know, Mr. Claremont, you couldn't say anything in court openly because there's a lot of confidentiality regarding juvenile proceedings. So therefore not everything is proper for the record. But now we're all here. And it's weird because the judge is acting as this mediator, which again is not even authorized under the rules. So I explained to him, well, the problem is that even given everything that's been discussed, the father, who is the primary custodial parent or guardian of the victims, who has a say and a right to a say, does not consent to any type of plea resolution that's not the fullest extent of punishment under the law. And he said, well, but it's your job to explain to him what he can and cannot get for his little girls. And I explained, I did. Again, and again, and again, and again. There is nothing I haven't said to him. There's nothing I haven't tried. I have been a straight shooter with him from day one, and I've explained to him strengths and weaknesses of this case, and that he can't get what he really wants, and that we really need to take the best interest of his daughters to heart in terms of what will happen if this trial plays out the way he envisions. So then at that point, everyone turns to the father and is looking at the father to see what he's going to say. So he says, Your Honor, and he goes into detail about what the case is about. And he says, now, Your Honor, I want you to imagine that you are the father of these two little girls, and that you are the one that is now being asked to enter this horrible, pathetic excuse for a resolution for your two little girls. What would you do if you were in my shoes? Oh my goodness. Silence in the room. I'm like, this is not going to go well. And the judge just kind of sits back, smiles, and he says, well, sir, I'm not the father of the victims. He says, but hear me out, entertain it. Please, give me an honest answer. You say we're being honest with each other here. I want your honesty. Tell me how you honestly would feel. This is what he's telling the judge. The judge says, well, if something like this happened to my children, I'd want to kill the bastard. Okay, that's interesting for a mediation. All right? I don't think, as a mediator, that's something that should have ever been said. I mean, it's honest, don't get me wrong, but at that point, neutrality's out the window. And so now the father feels totally vindicated. He's smiling like, finally, someone gets it. And the judge goes, well, that's how I would feel, but that doesn't mean that's what I would do. And he says, well, Your Honor, what you said is the crux of the matter. And so when Prosecutor Claremont's over here telling me these things about how there's problems with the case, how we have to spare this and worry about that, I don't want to hear it. I want to hear blood and vengeance. And so that's why every time he comes to me with this plea negotiation crap, I tell him, go fuck yourself. Everyone in the room is speechless. Now the judge understood. He paused, licked his lips, and he said, well, I guess we're going to have a trial. Because he understood his hands were tied. There's nothing he could do further. He can't tell this father at this point. He's whatever type of negotiation that could be had that day was completely shot. Completely shot. And so he thanked everyone for coming and ended the mediation as an impasse. And he understood now. He understood what I was up against, because when the father had used that language in front of the judge, and when the father gave me the finger in front of everyone in the room, he realized that I was in a real bind. That I had at all times maintained decorum, civility, politeness, that I had been understanding, empathetic, sympathetic. He understood that this man was pushing my patience, but that I would not crack, that I was professional all throughout. And so he realized that now there's really no reasoning with him. And so at that point, the only thing you can do is to let the process play out and then revisit the subject of the negotiations. And that's exactly what did happen. At some point, finally, the victims were set down for depositions. The saddest thing that could ever happen. The defense attorney was just doing his job. He was a good person. I don't look at him in any way as being the villain here, because he has to defend his client. And so he has to ask the questions and see what the state's case is all about, so that he can try to get the best outcome for his client. And I can't fault him for that. But I had warned the father that that would happen. And I had warned the father that when that happens, what happens to those little girls is on him. Because he told me, remember, earlier in the story, he told me, you do your job, and I will worry about whatever happens to my little girls. I will take it all on me. So he's present for these depositions, because the children are allowed to have their parents present. Can't interfere or do anything on their behalf, but he can just watch. Not a dry eye in that room. Prosecution's crying. Defense is crying. I'm talking about attorneys doing their jobs. They're crying. Why? Because it's heartbreaking. As a human being, you can't see this and not feel a part of it, and not feel the pain and the anguish of what is going on. The victims, absolutely. Well, actually, they did them one at a time. So at that point, it's just one of the two sisters. But that little girl was crying. She really didn't want to relive that day at all. And we're forcing her to. And it's hurting her. But the defense can't stop, because they have to defend their client. And so with each successive question, it gets worse and worse, until finally the father is crying. And now he gets it. He understood that I was being honest all along, that I was giving it to him straight all along, that I was making him understand all along what was going to happen. That I wasn't some lazy bastard, that I wasn't incompetent, that I wasn't a moron as he depicted me, that everything I told him is exactly what was going down. And it hit him. That's the point where the villain realizes, I have made a grave mistake. And because, like I said, he's an accidental villain. He's not a fully committed to evil villain. He's an accidental villain. He had the best of intentions. He's allowed to be upset over what happened to his little girls. But he just had a tunnel vision, and he wasn't seeing outside of his path for vengeance. And so he didn't think this all the way through. And so now, as everything hit him and he fully saw what was going on, he's like, stop. I can't do this anymore. Stop the deposition. Stop, stop, stop. At that point, we go talk in private, and now we have a plea deal. But it's unfortunate it took going to that extent to finally reach that outcome. An outcome that could have been easily reached months and months before. But for the hard heart, sometimes it takes the full truth to finally get a supervillain to realize that the trait they have is hurting them and hurting everyone around them. So that's the lesson to be learned here, is you have to be brutally honest and upfront. You can't sugarcoat a thing. They must know the strength of the case. They must know the potential consequences. They must know it all, so that they can make the best informed decision, one that will make them realize that negotiation on these terms is the best outcome. So exactly what we were proposing all along is exactly the resolution that took place. The defense jumped over it. The defense had never had an issue with accepting the usual plea arrangement that we would give. Except it was just the victim's father. And once he finally saw the light, the case was resolved. Thank you.